kung sila po mismo ay hindi sumusunod sa tuntunin? Bakit po ngayon ay napakarami pong nagsasalita na parang akala mo ay ang Supreme Court pa ang nagkasala? The question whether is it
Yes, your
subject
basis
to
for
appeal?
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes, yes. May I have a speculative answer, Mr. President?
Okay, so ayan po ang mainit na debate nitong si Senator Sotto at itong si Senator Marcoleta. Yan ang papanuurin natin, no, kung gaano po ginisa nitong si Marcoleta, itong si Senator Sotto. At panuurin po natin ng buo itong privilege speech, no, na mainit at matinding privilege speech na sobrang galing nitong si Senator Marcoleta patungkol po dito kung i-dismiss ba ang impeachment trial laban dito kay VP Sara. Okay? So yun po ang papanuurin natin ngayon at i-react natin ito. Okay? Pero bago ang lahat, bago natin ito papanoorin, help me po muna na i-like at saka i-share itong video na ito para guys kakalat ito sa taong bayan. Okay? O, sabay-sabay muna tayong mag-like and share sa Donmar TV. Itong video na ito, like and share. 1, 2, 3, go! Okay, naka-like and share na ba lahat? And also guys, sa mga bago pa lang dito sa aking channel, mag-subscribe na po kayo para lagi kayong updated sa ating mga balita. And at the same time, yung mga cellphone ninyo, ma-notify yan kung meron tayong breaking news, bagong uploads, o kung nagla-live ang ating channel. Ma-notify kayo lahat dyan. Kaya mahalaga po na mag-subscribe tayo sa Donmar TV. 1, 2, 3, go! Ayan, nakasubscribe na ba lahat? Sa video pong ito, ipapakita natin itong privilege speech ni Senator Marcoleta na inexplain niya bakit sobra pong mali itong ginawa ng House of Representatives at bakit tama naman itong ginawa ng Supreme Court. Okay? So, without further ado, pakikinggan po natin itong privilege speech ni Marcoleta para po makakuha tayo ng idea, okay? Bakit kailangang i-dismiss itong impeachment trial na ito? Okay? So, Marcoleta, pasok.
Thank you, Mr. President. Mr. President, I rise on a question of privilege. Today, I believe the entire nation awaits the disposition of the matter in regard to the impeachment complaint filed against the Vice President, Sara Duterte, in the light of the recent but unanimous decision of the Supreme Court. Mr. President, this decision was promulgated on July 25, 2025, declaring said complaint to be unconstitutional, void ab initio, violative of due process, and that the Senate in the first place did not acquire jurisdiction over it. Take note, Mr. President, it even said that the decision is immediately executory. But before I continue, Mr. President, let me put on record that the initial proceedings, impeachment proceedings conducted by the Senate in the 19th Congress have never been formally carried over to the Senate of the 28th Congress. I do not know and I'm not aware, I cannot recall of any action so far taken by this august chamber to the effect that the initial impeachment proceedings, which were deemed to have been terminated at the expiration of the 19th Congress at noon of June 30, 2025, have been miraculously brought to life into the present Congress. That having said, Mr. President, I'd like to continue. Mr. President, the decision of the Supreme Court did not dwell on the intrinsic merits of the impeachment complaint filed against the Vice President. It zeroed in merely on the procedures and the processes taken by the House of Representatives. To repeat, it declared the whole impeachment complaint constituting the articles of impeachment to be unconstitutional, violative of due process, void ab initio. Simply because the rules of procedure in impeachment proceedings in the House of Representatives were never followed. And they violated the one-year ban on multiple impeachment complaints as prescribed under Article 11, Section 3, Paragraph 5, which says that no impeachment proceedings shall be initiated against the same official more than twice within a period of 1 year. Napakasimple po ng sinasabi doon, Mr. President. No impeachment proceeding should be initiated against the same person more than twice within a period of 1 year. Ilan po ang impeachment proceedings, impeachment complaints na ipinail ng House of Representatives? 4 po eh. The first one started in December 2. Sumunod po December 4. Meron pang sumunod na December 19 hanggang sa umabot po noong February 5. Yun nga pong ipinangangalandakan na impeachment complaint which was signed by more than 1/3 of the members of the House of Representatives. Nasunod po ba? Nasunod po ba ang tuntunin ng House of Representatives? Noon pong nag-require ang Supreme Court, Mr. President, tinanong po yung House of Representatives in connection with the 2 petitions filed by several parties before the Supreme Court. One of the items required by the Supreme Court is for the House to give the status of the first 3 complaints filed. Ano po ang sagot ng House of Representatives? Yun daw pong unang 3, the one filed in December 2, December 4, and December 19, were all archived. Nasaan po sa rules ng House na yun pong mga impeachment complaints na ifa-file ay archive? Wala po. Pwede po bang ipakita yung slide na kung saan ay makikita natin ano po ba ang proseso kapag may nag-file na isang impeachment complaint? Ayan po yung Rule 2. Ang sinasabi po sa Rule 2, Mr. President, hindi sa Rule 3, sa Rule 3. Rule 2, Section 3. A verified complaint for impeachment by a member of the House or by any citizen upon a resolution or endorsement by any member thereof shall be filed with the office of the Secretary General and immediately referred to the Speaker. Bakit hindi po nasunod ang tuntunin na ito, Mr. Speaker? Kailan po ni-refer ng Secretary General sa opisina ng Speaker yung impeachment complaint dated December 2, 2024? Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint na i-file noong December 4? Wala po silang sagot. Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint that was received on December 19? Wala po silang sinasabi. Kapag titingnan po natin ang sagot ng Solicitor General in behalf of the House of Representatives, ang sabi po nila, the Secretary General diligently referred simultaneously all the impeachment complaints to the Office of the Speaker on February 5, 2025. Immediately po ba yan, Mr. Speaker? December 2, December 4, December 19, at isinama po yung February 5, all of them were simultaneously referred to the office of the Speaker on February 5. 2 buwan po ang kanyang ginugol para lang i-refer sa office of the Speaker. Ano po ang immediate doon? Wala po. Wala po silang sinunod. Wala silang ni-refer at ni-refer nga po delayed. Nung ma-refer po, ang sabi po ng Solicitor General, the 4 impeachment complaints were included in the order of business doon po sa session number 36. You will note, Mr. Speaker, hindi po niya ibinigay bilang annex yung order of business in section number 36. Ang kanya pong ipinakita ay yung journal number 36. Bakit po? Sapagkat hindi totoo na yung 4 na impeachment complaints were included in the order of business. Mr. President, I have a copy of the order of business, session number 36. And I will deposit a copy to the office of the Senate Secretary for everyone to see and examine for themselves kung talagang in-include nila sa order of business. Wala po. Saan po nila in-include? Doon sa journal. Iba po yung journal sa order of business. Alam po niyo kung bakit lang nalagay sa journal, Mr. Speaker? Idinagdag po nila as additional reference of business. That is not the requirement of the Constitution. Pwede po ba nating makita yung slide, ano yung sinasabi po ng Constitution? A verified complaint for impeachment may be filed by the member of the House, blah, blah, blah. Ang sinasabi po rito, iba yun. Hindi po yun. Sorry po. Nakalagay po, in-include sa 10th session day. Yun po yung section number 36. Hindi po totoo yun. Ilang violations na po? Kanina po, in-archive po yung tatlong violations. Hindi po ni-refer sa Committee on Justice. Pangatlong violation. 6 na po. Ngayon sinasabi po, in-include po sa order of business. Hindi rin po. 3 violations na naman. 9 na po. At sabi po nila, yung session 36 is the 10th session. Hindi po. Bilangin po natin yung December 2. That was the date when the first complaint was filed, endorsed, and received by the Office of the Secretary General. December 2 is session number 26. Mr. President, bilangin po ninyo session number 26 up to session 36 na sinasabi ng Solicitor General. Yun po ang 11th session. That was not the 10th session. Ang 11th session is session number 35. Just for the record, Mr. Speaker. So ilang violation na po yan? Balikan po ninyo yung Rule 2 na nandyan po sa slide, Mr. Speaker. Ano po yung mode of initiating impeachment? Ganito po ang sinasabi ng rule of the House of Representatives. Impeachment shall be initiated by the filing and subsequent referral to the Committee of Justice. Ito po yung Sereno versus, Francisco versus House of Representatives. Verified complaint for impeachment filed by any member of the House of Representatives, i-refer po sa Committee on Justice. Verified complaint filed by any citizen upon a resolution endorsement by any member thereof, i-refer po sa Committee on Justice. A verified complaint or resolution impeachment filed by at least 1/3 of all members of the House, i-refer din po sa Committee on Justice. Bakit po ang ginawa nila nung makakuha sila ng higit sa 1/3, dali-dali po nilang tinransmit sa Senate? Ang pagkakakala po nila, Mr. Speaker, sapagkat ang pinagbatayan po nila ay yung Rule 4 na kung saan in Section 14 sinasabi po endorsement of the complaint resolution to the Senate. Ang sinasabi lamang naman po noon, Sir President, ay yung pamamaraan kung paano po i-endorse yung impeachment complaint that was signed by 1/3 or even more members of the House of Representatives. Hindi naman po sinasabi doon na hindi na siya i-repair sa Committee on Justice. Bakit po nakalagay dito sa rule? Kailangan i-repair din siya sa Committee on Justice, but they never did. Mr. Speaker, Mr. President. So ilang violations na po ito? You cannot use Section 14 in isolation of Section 2. Hindi po pwede yun. Binigyan po ba ng discretion, Mr. President? Was the House given the discretion to select, to withhold and select from among the 4 impeachment complaints, which will be the one to be transmitted in the Senate in derogation of the 1-year ban rule? Wala po silang discretion. Kung sila po mismo ay hindi sumusunod sa tuntunin, bakit po ngayon ay napakarami pong nagsasalita? Na parang akala mo ay ang Supreme Court pa ang nagkasala, ang nagkamali. Samantalang ito po, napakasimple po ng tuntunin, hindi kailanman sinunod. Even the 10th session day na sinasabi nila, 11th session day nung ilagay po nila sa order of business, sabi nila, they never included them in the order of business. Wala po. Nasa akin po yung kopya. Ano ba po ang pagkakamali? Mr. President, ipakita po natin yung last page ng impeachment complaint. Pakita po sa slide. Ayan po, Mr. President. Subscribed and verified before me. Sabi po ng Secretary General. Saan ba yung kopya ko rito? Subscribed and verified before me on this blank day of February 2025. Wala pa pong date eh. Ito po ba ang verification, Mr. President? Hindi po. Ang verification po ay nakasaad po sa mismong tuntunin ng House of Representatives. Balikan po natin ang Section 3. Ano po ang sinasabi? Section 3, Paragraph 2. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. At the very least, yun ang dapat na ilagay po. Nakalagay po ba sa verification dito? Ng Secretary General ng House of Representatives? Wala po. Ito po'y parang jurat lang sa isang affidavit. Sinasabi lamang po dito, kilala niya yung nagsipirma sa isang dokumento. Na ang dokumento ay naglalaman ng 32 pages. This is not the verification required under the rules of impeachment by the House of Representatives. Ang totoo po, kung balikan po natin ang Section 14, nandyan po sa slide. Isinulat na po sa tuntunin kung ano po ang dapat kopyahin nila para magkaroon ng tunay na verification. Hindi pa po nila kinopya. Mr. President, ito po yung contents ng verification na dapat sana yun ang nilagay nila sa complaint. We, sabi po rito, after being sworn in accordance with law, depose and state that we are the complainants in the above entitled complaint or resolution of impeachment, that we have caused the said complaint resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our own reading and appreciation of documents and other records pertinent thereto. Kokopyahin na lang, Mr. President. Hindi pa nakopya. Mr. President, alam mo po, nung ako'y grade 4, yung teacher po namin, binigyan po kami ng isang short quiz. I-drawing ninyo kanya yung Bicol region. Siguro po 1963 yun, Mr. President. Yung Masbate, hindi pa kasali sa Bicol region. O hindi, kabisado ko naman po sapagkat mahilig po ako sa social studies, Mr. President. Meron pong dalawang nangungopya sa akin. Yung isa nasa likod, yung nasa kaliwa ko. Yung nasa likod po, nakopya niya pong tunay yung aking drawing. Pinagalitan siya pero ipinasa po sapagkat nakopya niya po yung aking drawing. Yung isa po, nangopya na nga, hindi pa niya nakopya. Ang kinopya po, mas bate. O wala po. Hindi po siya nakapasa. Ano pong ibig ko sabihin dito? Kokopyahin na lang eh. Alam po ninyo sa mga litigation lawyers, practicing lawyers worth their salt. Wala ka lang certification of non-forum shopping, i-dismiss ka ng Supreme Court. Paliwanag po yun eh. Hindi subscribe yung complaint mo, dismiss ka kagad. Mahigpit po ngayon eh. Ito po, this is an impeachment complaint. You are removing the second highest official of government. Yun lamang pong verification eh. Sablay na po eh. Ano pong nakalagay dito? Section 3, paragraph 3. An impeachment complaint required to be verified which contains a verification based on information or belief or upon knowledge or information and belief or lacks proper verification, katulad po nito ngayon, shall be treated as an unsigned impeachment complaint. So pwede pong tratuhin pala ngayon sapagkat wala pong verification eh. It may be treated as unsigned impeachment complaint.
Klaro yan, klaro yan.
Bakit magsasalita po ng napakarami?
Very clear.
Alam po ninyo kung, Mr. President, kumbaga po sa nagluto ng sinaing, pasensya na po kayo kung kinakailangan ako po'y gagawa ng pagkahalin tulad, ano. Ang impeachment complaint po ay parang sinaing na niluto ng House of Representatives. Hilaw po eh. Hilaw na hilaw. Ano po yung hilaw sa Bicolano, Mr. President? Hilaw din po yata. Sa Bisaya, hilaw din po. Sa Kapampangan, magadto, Mr. President. Sa Waray po, matagudtod. Sa Ilonggo po, lagdos. Sa Ilocano, marakusol. Sana po tama ang aking pagkaka-pronounce. Ang dami pong nagsasalita, Mr. President. Doon lang pa po sa House of Representatives, isa pong bagong pasok doon. Ngunit matagal na pong nagserbisyo sa ating bansa. Naging senadora, naging Secretary of Justice, naging chairman ng Human Rights Commission. Alam po ba kung ano sinabi niya sa isang panayam? Ito po, nakuha ko. Harap-harapan na tayong niloloko. Kakaibang korte ito. Sana sa palengke na lang final ang impeachment case. At least doon, may nagtitinda ng totoo. Sana po, magtinda po siya ng matagudtod na kanin dyan sa Samar. Baka may bibili kaya. Pwede kaya siyang pumunta dyan sa Pampanga po para magbenta ng magadto na kanin. Kung may bibili, baka sakali. Pumunta kaya sa Panay para magbenta ng lagdos na kanin. Wala po siguro, Mr. President. Baka ngayon dagan dingding, hindi pa patusin eh. Huwag pong ganun. Ang dami na pong nagsipagsalita. Samantalang hindi po nila nakita. Ang dami, kayo po nagsimula ng mali. Hindi naman po sinasabi ng Korte Suprema na kailanman ay huwag kayong mag-impeach, huwag na kayong mag-file. Ayusin nyo lang po eh. Yun lamang po ang gustong mangyari dito. Ayusin nyo. You want to impeach the Vice President, do it in the right way.
Correct.
Hindi naman po tinignan ng merito eh. Ang sinasabi yung proseso, hindi po nyo sinunod eh. Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang apat po kagad ang ipinay. Pagkatapos yung apat, i-consider mo na isa. Hindi naman po yata tama yun.
Booking sila dito.
Mr. President.
Wala talaga. Sunog sila kay Marcoleta ng House
Mr.
of Representatives.
Gusto ko pong basahin isang parte ng official statement of the Integrated Bar of the Philippines and the Supreme Court's decision in Duterte versus House of Representatives, August 1, 2025. And I quote, "Disagreement with the court's reasoning is neither unwelcome nor unexpected. Dissent is not foreign to a democracy. It is essential to its survival. But to incite public repudiation of its authority, or even just to call for its outright defiance, erodes the very foundation of the legal order. Such actions disturb the equilibrium of powers and imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. The law ceases to be a constraint on power and becomes its casualty. The Constitution does not require agreement. It demands adherence." Ang sinasabi po ng mga ibang kasama natin, magpapile pa naman ng motion for reconsideration. Bakit hindi natin hintayin? As I said, Mr. President, if you are a practicing lawyer worth your salt, you are confronted with the unanimous decision of the Supreme Court. In a firm voice, it says this is unconstitutional, void ab initio, violative of due process, and the Senate never acquired jurisdiction over this. And it is immediately executory. Parang sinasabi niya sa'yo, wala ka ng room mag-file niyan. Is anyone expecting that even one soul of the members of the Supreme Court will reverse himself? We cannot depend our action, Mr. President, on the fortunes of litigation. Naalala ko pa nga po doon sa kaso ng Francisco versus House of Representatives. The former Chief Justice Renato Puno, in a separate concurring opinion, naalala ko po ang sabi niya, with the possibility of 2 impeachment complaints reaching the Senate, the good Chief Justice said that the Senate, in the exercise of its primary jurisdiction, can decide the question of whether or not the 1-year bar rule has been violated or not. The Senate can even decide if on its face the impeachment complaint has no legal basis. At ang sabi pa po niya doon, Francisco versus House of Representatives, sabi pa niya ron if the Senate finds that the 1-year bar rule is violated, or that the impeachment complaint has no legs to stand on, that will be the end of the entire controversy. He was saying that let's give all the remedies available to the House and the Senate because of their primary jurisdiction. But when the case is ripe for judicial determination, it was the view of the former Chief Justice that the Supreme Court at that time, and only at that time, when it can speak with great moral authority in order to compel the loyalty, the respect, and the obedience of our people. Mr. President, when the Supreme Court negates the actions of a co-equal branch of government, it does not assert its superiority. Instead, it upholds the supremacy and the dominance of the fundamental law of the land, the Constitution. And so the Supreme Court has already spoken. The last arbiter of law, it says the complaint is unconstitutional, it's void ab initio, it's violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President, I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
Okay.
Never miss a story.
So, yun po ang full speech ni privilege speech ni Rodante Marcoleta, ha? Kayo ba po sang-ayon doon sa kanyang mga sinasabi na i-dismiss itong impeachment trial na ito? Pero wait kayo, kasi itong si Senator Sotto ngayon ay tinanong pa itong si Marcoleta. Ito, debate ni Marcoleta at itong si Senator Sotto. Okay, pasok.
Thank you, Mr. President. If the distinguished gentleman from Tarlac favor me with a few questions, I will be gladly accepting his favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed. Should Senator Marcoleta so allow it?
Yes, Mr. President.
Thank you, Your Honor. Thank you very much. Mr. President, thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR, or the motion for reconsideration, filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your
subject
basis
to
for
appeal?
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor. That's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final, thus appealable. Ngayon, naka-apela na. Marami nagtatanong, kung naka-apela na, ba't tayo nagmamadali? Na-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping...
Kasi si Sotto, hindi yan lawyer. Pero itong si Marcoleta, lawyer po ito. Kaya nga, itong si Sotto ngayon, pinagtawanan ng mga lawyer. Sino ba namang mag-reverse dyan sa Supreme Court? Basing sa kanilang experience, hindi na po yan marireverse. Unanimous yan. Diba? Ikaw, Sotto, hindi mo maiintindihan yan kasi hindi ka lawyer eh. Diba?
Against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone,
lumalaban talaga si Sotto kahit hindi lawyer.
the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. In the case of Labogal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lili
Bakit naman nyo ikukumpara yan, di ba?
Lopez versus Lolito Lopez with GR numbers 25497-957-58. So, may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
Yeah. Patay ka dyan. Patay ka dyan, Soto. Kasi we're talking about yung reverse. So, tinanong siya ngayon, yung mga in-example mo, kagaya ba yan ng impeachment trial sa Supreme Court na naging unanimous decision yan? Sagot.
I am not sure about that. But one thing I can say is that
Akala ko ba nagre-research ka? Di ba? Yung tinanong ka lang kung unanimous decision ba, hindi mo masagot yan. Akala ko ba nag-research ka at alam mo yan?
if there is a mistake, a unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's
Soto, hindi ka makakalusot ni Marcoleta.
unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ng kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands?
Pinagtawanan ka lang ni Marcoleta, oh. Natatawa na si Marcoleta.
Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyan ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives.
Correct.
Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question. But then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canaldac has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation, with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress, but us, it is a big deal. That's why I'm stressing this point. concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mamali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsod, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo. You even sent out summons Ano yun? June 9, the Senate President took his oath. June 10, nag-convene ang impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin nyo mabuti. Uli, ang dami, gagaling ng mga abogado rito. Basahin nyo. It even quoted the entire Article 11 of the Constitution not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has, the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, I have a quick reaction to the manifestation of the gentleman.
The gentleman may do so if he so desires.
Mr. President,
Sound check.
in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag kami 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distinguish pa natin yung adjournment and sine adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ng Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Sotto, and first movement of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week, that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished minority floor leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President.
Never miss a story. Unlock exclusive.
Dami pang palusot itong si Senator Sotto. Motion to dismiss pa rin yan hahantong, di ba? So, at the end of the day, no, nabalitaan naman natin na majority talaga. Mga apat siguro yung mga nag-vote ng no. At yes is about 19 o 20 yung nag-yes, i-dismiss. Isa lang yung nag-abstain, which is si Panfilo Lacson. Okay? So, ano masasabi nyo dito po sa debate ni Marcoleta at itong si Senator Sotto? Mag-comment, mag-react po kayo. At sa privilege speech rin ni Senator Marcoleta, tama bang i-dismiss itong impeachment trial ni VP Sara? Mag-comment, mag-react at babasahin natin yung mga comments ninyo at usap-usap tayo sa comment section. Okay? Sa mga bago pa lang dito sa aking channel na ngayon lang nanood dito sa ating vlogs, libre kayong mag-subscribe, no? Wala pong bayad yan. So, if makasubscribe kayo sa ating channel, updated na po kayo sa ating mga balita. Okay? So, subscribe na po. Subscribe na kasi libre lang yan So, guys, see you in my next video. Have a great day. Have a great night. And God bless po sa ating lahat. Mabuhay ang Pilipinas. And God save the Philippines. Bye-bye.